Hi, Tim Blankenship here with Divorce661.com again. I had an interesting question from a potential client of ours yesterday that called yesterday. They were attempting to do their divorce on their own, had filed for divorce, and were doing some of the property declarations and needed to draft their judgment, and that's where they got kind of stuck. And so they called us. And what they were trying to do is they thought, because they were trying to do a default style divorce, default with the agreement, they thought that they had to come to an agreement, but that agreement had to be exactly 50-50 splitting up of the assets and debts. And that's not the case. So here's the confusion. When you do a default, a true default where the other party is not involved, the courts generally have to use California law and apply that and say all assets and debts need to be divided 50-50. However, when you're doing it by agreement, and this is of course the benefit, you don't have to do it exactly by agreement, or you don't have to do exactly 50-50. So the question was, Tim, we're trying to divide up everything 50-50 and we're just having a hard time. And I said, when it's done by agreement, you do not need to have it exactly 50-50. And they said, well, how isn't the court going to verify that the amounts are equal that each party is getting? And in a default, that is true, but in a stipulated agreement, and this can be a default with an agreement, that is not true. In fact, and what she was surprised to hear is we're not even going to supply the court with the actual values of the assets and debts that each of you are keeping. So in a default, you have to do those FL 160s. And if you're going through the process, you know what I'm talking about. You don't have to do those 160s if it's by agreement. So we never recommend doing the 160s. We never do them in our default cases that's by agreement, because there's no sense in giving all of this information to the courts. When we go to draft your judgment, as we're going to be doing with this client of ours now that's called us the other day, is we are going to just indicate that the house is going to one party or the other, that their 401ks are just listed by account number of who's keeping what. There's not going to be any assets or debts listed by full account number or any values provided. Again, just one more benefit to doing your divorce with us and having information like that available to you. So please give us a call if we can help you with your divorce in California. Tim Blankenship, Divorce661.com, 661-281-0266. Thanks for watching.